Hello and welcome. Citizenship Amendment Act 2019, it is in news again. A lot of you would be confused that why it is in news again when it was there in the year 2019. Thing is, Citizenship Amendment Bill, it was brought in the year 2019, and the same year the bill, it was passed in both the houses, got assent of the president, and we got an act. But before an act becomes a law, what the government has to do is the government has to give rules, the government has to notify the rules through which the act will be implemented. Starting from 2020 till 2024, the government requested multiple extensions on how to implement the rules, what will be the rules of implementation. So the rules we got framed in these 4 years, and then in the month of March 2024, the rules to implement Citizenship Amendment Act 2019, they were notified. So hence it is in news now. And regarding Citizenship Amendment Act, a lot of people are confused regarding what exactly are the provisions. Is it going to impact my citizenship? Is it going to impact a specific community in India? All these doubts are there. So before we remove all those doubts, before we get into the concept of Citizenship Amendment Act, first let's discuss the basic concepts of citizenship. Because only when we know the concepts of citizenship, the advantages of citizenship, then we will be able to understand better what Citizenship Amendment Act is. Alright, so and then obviously what will be the course of this discussion is, we discuss the concepts, what is citizenship, who are citizens, who are migrants, we discuss them, then we discuss how citizenship is given in India, and then we come to the act, we come to the rules, and then we discuss about the issues and the arguments in favor of the act, arguments against the act, and then we go forward. Alright, so let's start. So when I say Citizenship Amendment Act, first of all, what is a citizenship? Citizenship, it is a relationship, it's a legal relationship between the state and the residents. So who is the citizen or who is a resident? Now, if we say that this is the territory of India, if this is the territory of India, then in this territory we have two type of people who are staying. One are those who are citizens of India and others are aliens. Aliens means who are not citizens of India and are basically citizens of some other country. So who are citizens? Citizens are those residents in this territory who owe allegiance to the state. At the same time, so what's the parameter? They owe allegiance. At the same time, they also enjoy certain civil and political rights. For example, in India's case, it is only citizens which enjoy the rights of Article 15, Article 16, that is right to equality, Article 19, right to freedom of speech and expression, and Article 29 and Article 30, which are cultural and educational rights. So these rights are available only to citizens. Similarly, only citizens, they have right to vote. Only citizens, they have the right to contest the election of MP or MLA. Only citizens can become president, vice president, governor, advocate general, attorney general. Only citizens can apply for government jobs. So these are the advantages, these are the positives which citizens have. But at the same time, we also have other people staying in the country who are aliens. They are basically the citizens of other countries. And these aliens, they can be of two types, friendly aliens, enemy aliens. Who are friendly aliens? Friendly aliens are those people who are residents of or citizens of those countries which have a healthy relationship with India. For example, the residents of US, residents of Australia, residents of Switzerland, all those citizens basically. So citizens of these countries, if they are staying in India, they are friendly elements. They're friendly aliens. For example, all players who are playing in IPL right now, they are friendly aliens in India. And what are enemy aliens. Enemy aliens are citizens of those countries which are at war with India. Now, China may have regular border tensions with India. China may have skirmishes with India, but China is not at war with India. So even if we have Chinese citizens who are staying in India currently, they are also the friendly aliens, they are not enemy aliens. If I talk about enemy aliens, they do not get the protection of Article 22. Article 22, it gives protection against arbitrary detention. So friendly aliens cannot be detained without any reason, but enemy aliens, they do not get the protection which is given under Article 22. Now, if I talk about aliens, we can also classify them into legal migrants and illegal migrants. So what are legal migrants and who are legal migrants and who are illegal migrants? Thing is, suppose I am a Bangladeshi and I want to go to India for a specific reason. That specific reason may be I am going for higher education. I may be going for, say, hospitalization. I may be going for economic reason. I may be going for a tourism. There may be any reason. So how do I go for it? In that case, I would go to an Indian embassy in Dhaka and would apply for Indian visa. In that case, I would be entering into India legally and I would be a legal migrant. And that visa would have a specific tenure, visa would have a specific period, that for this time period I can stay in India, say for a period of 1 month, 2 months, 3 months. Suppose the period of my visa is 3 months. So if I stay in India for 3 months, I would be a legal migrant. But suppose I stay in India beyond a period of 3 months. I am staying in India beyond a period of tenure of my visa. In that case, I have become an illegal migrant. So how does a person become legal migrant? Only if he enters India, or say any other country, enters India through valid documents, through legal documents, and stays till the tenure of the document. Who is the illegal migrant? Like feature 1, he is entering into specific country but is staying beyond the tenure for which the visa is. Second is, if someone is sneaking into India without documents, getting advantage of the porous borders, getting into India without any document, he is also an illegal migrant. I hope that's clear. Then we have another category which is refugees. Now refugees are basically, I would say, a subset of illegal migrants. So who are refugees? Refugees are those people who are coming into our territory. They are entering illegally, or they have entered legal but are staying beyond the time period of their visa, and they are doing so because they have a fear that they would be persecuted in their country because of their religion, because of their nationality, or because of their ethnicity. These people are classified as refugees, those who have a specific reason for their persecution, they are afraid persecution. And refugees, the right of refugees, it is governed internationally through the Geneva Convention. International Convention for Refugees, also called as the Geneva Convention 1951. So we have refugees covered under Geneva Convention of 1951. It is the international mechanism for dealing with the plight of refugees. This convention actually tells who is the refugee and like what what rights can a refugee expect in a country in which he is immigrating to. At the same time, it also tells what will be the duties, of all these refugees when they enter into a specific country. India hasn't signed Geneva Convention on Refugees. Fair enough? Right. Now, so these are the classifications of residents. We have citizens, we have aliens, we have migrants, which was discussed earlier. So we have illegal migrants, and all those things. I just forgot one thing, which I forgot to tell you one thing. I told that citizens, they get certain rights from the government. They get certain rights from the government, but at the same time, citizens also have certain duties towards the state, towards the government, towards the state, I would say. So what does the state do? The state, it confers certain rights to the citizens, and citizens also have certain duties towards the state. Duties like paying taxes, duties like protecting the country, duties like protecting or respecting the symbols of national respect. For example, national anthem, for example, national flag, they need to respect it. So these are residents, citizens, and aliens. Now citizenship, it is granted based on two ways. One is jus soli, and other is jus sanguinis. So what is jus soli? Jus soli, it means right of soil or law of soil. So if the citizenship is given because of birth on a specific soil, it is called citizenship because of jus soli, and this method, it is followed in US. For example, if we have two Indian citizens and they go to US and the child takes birth in US, then that kid, by virtue of his birth on US soil, is a US resident, is a US citizen. He can apply for citizenship of US because there is right of soil. The citizenship is given based on soil. At the same time, in India, we follow the concept of jus sanguinis, which is citizenship because of blood, because of descent. For example, who gets citizenship in India? A person who is born in India, or if a person who is born to Indian citizens but outside India. Suppose again, the two Indian citizens, they go abroad, and their kid, he takes birth over there. Still, he would be an Indian citizen because both the parents are Indians. Alright, so he gets citizenship because of his descent. Now, so these are two concepts through which citizenship can be given, that is jus soli and jus sanguinis. Alright. Now, if I talk about constitutional provisions regarding citizenship, you won't believe. Most of the countries in the world, they give citizenship through an act made by the parliament, act made by the government. There's hardly any country in the world which has constitutional provisions for citizenship. Why does India have it? In India's case, it is part 2. In India's case, it is part 2 of Indian constitutions, and we have Article 5 to 11, which talk about citizenship. India has a specific case. Reason is, India was a country which was facing partition, that too based on religion. So Indian government, it had to be very, very clear regarding who would be citizens of India, and who would not be citizen of India. So in India's case, citizenship is given not only through an act made by the government, but is also given through constitutional provisions. Constitutional provisions for giving citizenship in India are covered under Part 2, Article 5 to 11. So Article 5, it talks about those people, it talks about citizenship at the commencement of constitution. Alright, so basically Article 5 talks about those people who had taken birth in India Article 6, it talks about those people who have migrated to India from Pakistan. Article 6 talks about those people who have migrated to India from Pakistan. Article 7, it talks about citizenship of those people who had migrated to Pakistan and then have come back to India. Then Article 8, it talks about citizenship of people who are of Indian origin, person of Indian origin. Who is a person of Indian origin whose ancestors are Indians? Alright, they are persons of Indian origin. Article 9, it talks about that, if someone is acquiring a citizenship of other country, if someone is voluntarily acquiring citizenship of other country, then he won't remain a citizen of India. Article 10, it talks about Parliament's right giving citizenship to the above three categories of people. Alright, and Article 11 is the one which is main point of contestation now. So Article 11, it gives the power to Parliament. That Parliament, that the Parliament has exclusive right. The centre has the exclusive right to make a law on citizenship in India, and it is exercising this right that the centre or the Parliament, I would say, it brought the Citizenship Act 1955. Now the Citizenship Act 1955, it gives citizenship based on these 5 provisions and then covered under Assam Accord. What are those 5 provisions under which Citizenship Act 1955 gives the rights? It is by birth, by descent, by registration, by naturalization. Let's do one thing. Let's talk about all of them one by one. How citizenship is given through birth. The citizenship is given, I would just put a summary of it. Alright. Citizenship is given to a person who is born in India if both his parents are Indian. Alright. If both of their parents are Indian, or one parent is Indian, one parent is a citizen of India, and the other parent is not an illegal migrant in India. That's the main crux. Person who is born in India, that's the one thing, and both his parents should be citizens. If both parents are not citizens, then what we can have is one parent should be Indian, one parent should be Indian citizen, and the other parent, yes, he can be from other country. He can be from other country, but the point is he or she should not be an illegal immigrant to India or illegal migrant to India. So that's the crux of citizenship by birth. Now, other is citizenship by descent. Citizenship by descent, it talks about all those people who are people of Indian origin. So it says, let's like this. Let this main thing. A person born outside India or after January 26, 1950, but before this specific date, is citizen of India by descent if his father was a citizen of India at time of his birth. It says that a person would be considered Indian citizen if the father was an Indian citizen. Now this thing was protested, that why only father? Why not mother? That if mother is also Indian citizen, why not to give him citizenship of India? Hence, it brought a change which said that if either of his parents is a citizen of India at the time of his birth, then also the person would be getting citizenship by descent. And the third provision, it says that starting from December 3, 2004 onwards, a person born outside India shall not be a citizen. It is given a negative thing, that only he won't be a citizen of India. He won't be a citizen of India only if certain conditions are met. What are those conditions? That unless his birth is registered at an Indian consulate within 1 year. Alright, within 1 year of his birth. So this is citizenship by descent. Now, what is citizenship by registration? Citizenship by registration, it talks about those people who are not born in India and who are not born to citizens of India, that is, who are not people of Indian origin. It talks about those people. So how can How can we have registration? How can we have citizenship by registration? We can have citizenship by registration only if a person has stayed in India for 7 years. First is, it talks about, basically talks about two different people. It talks about people of Indian origin. It also talks about people who are not Indians. For example, if a person of Indian origin and who has stayed in India for 7 years, he can apply for citizenship. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. And the third thing is, generally this is the one which is used when we have a case of marriage. For example, if I am an Indian citizen and if I marry someone who is, say, from Switzerland, who is, say, from Germany, that person is not born in India, that person is not of Indian origin, but that person is staying in India. So that person would be wishing to get Indian citizenship. So how do we do that? In that case, that person should be staying in India for a period of 7 years and continuously for a period of 12 months before applying for the citizenship. So a person who is married to a citizen of India and is ordinarily resident in India for 7 years before making application for registration. This is citizenship by registration. And this is citizenship by naturalization. In case of naturalization, what happens now? The person is not born in India, he is not a person of Indian origin, right? That is, he is not able to get citizenship by descent. Then he is not able to get citizenship by registration because he is not person of Indian origin, or he is not married to an Indian citizen. But still the person wants to get Indian citizenship. This is called citizenship by naturalization. In case of naturalization, here the process is little bit strict. In this case, the person should have stayed in India before making an application. Before making an application for citizenship by naturalization, in the preceding 14 years of application, if he is putting up application today, in the previous 14 years, he should have stayed in India for a period of at least 11 years. It's quite possible the person came to India, went back, came to India for 6 months, went back for 1 month. This to and fro happened in the last 14 years. But in these 14 years, the person has been able to stay in India for a period of 11 years. And again, one more thing, stayed in India for a period of continuous 12 months before applying. If this is the case, he can apply for citizenship. In all these cases, he is applying for it. It doesn't mean he would be getting a citizenship. He is applying for it. So, normal thing is that the process of naturalization, the time period for naturalization in India is 11 years. Fair enough? Now, and last is citizenship by incorporation of territory. For example, India acquired Goa, which was under Portugal. India acquired Puducherry, which was a French colony. So all those residents of Goa, all those residents of Puducherry, now when India acquired their territories, the residents of Goa and Puducherry, they have automatically become Indian citizenship to the clause of citizenship by incorporation of territory. There's one more thing to it. That one more thing is Citizenship Amendment Act 1986. This talks about those people who migrated to India from Bangladesh. Look, the period of 1969 to 1975, 1979 to 1985 actually, it was a period of protest in Assam. A lot of families, a lot of people from Bangladesh were migrating into Assam, and the people of Assam were worried about that it is bringing a damage to their ethnic culture. It's bringing a pressure on the resources over there. So what happened under Assam Accord? What did it say? That all persons of Indian origin who came to Assam before 1966 from Bangladesh, they would be declared Indian citizens. They would be deemed to be Indian citizens. But what about those people who were entering India between 66 to 1971? For them, they need to identify them. what they need to do is that every person of Indian origin who came to Assam on or after January 1, 1966, but before March 71 from Bangladesh, and who has been a resident in Assam since the date of his entry into Assam, and who has been detected to be a foreigner, shall register himself. He shall be registering himself. And once he has registered himself, then he would be considered an Indian territory after 10 years of his registration. Alright, let's not get into so much of technicality because not that important from UPSC perspective, the dates and all. What is important is the Assam Accord says all those people of Indian origin who came to India before 1971, they would become citizens of India. And all those people of Indian origin who came to India after Bangladesh, after 1971, they would be classified as illegal migrants. So what do the government do of illegal migrants? Illegal migrants in India are treated under Passport Act 1920 and Foreigners Act 1946. Illegal migrants are treated under these two acts. Alright? Passport Act and Foreigners Act. Under both these acts, illegal migrants, they would be deported to their parent country, or they would be imprisoned. So all those people of Indian origin who came to Assam after 1971 from Bangladesh, they should be deported because they would be illegal migrants. Now, this clause of 1971 is also one of the reason of disturbances in the Assam region. We'll discuss it shortly. Now let's come to Citizenship Amendment Act 2019. The act was brought in 2019, but the government had brought a similar notification to this in the year 2015 and 16, which said that if we have people of six religions, who? Hindus, Sikhs, Buddhists, Jains, Parsis and Christians. This, though I am underlining in 2019, I am talking about notification of 2015 and 16. If members of these six religion communities are coming from Pakistan, Bangladesh and Afghanistan before December 2014. Alright, I'll repeat. If we have members of these six communities, Hindus, Sikhs, Jains, Buddhists, Parsis and Christians, and they have come from three countries, Afghanistan, Pakistan, Bangladesh, these people will not be considered as illegal migrants. They won't be considered illegal migrants means they won't be deported or they won't be jailed. So that protection was given to people of these communities from these three countries. Protection was given that we won't be deporting, we won't be jailing, they can stay in India. But point is, don't you think that was putting the status of these people as in limbo? They were nowhere. They could not go back, they did not want to go back to their parent country, and in India they are not citizens. So who are they? What's their status? What should we do of them? Don't you think it is going against the right of dignity that they are not able to live a proper life? They are not able to apply for a government job. Hence, the Citizenship Amendment Act of 2019, it is actually upgradation of the notification of 2015-16. Because 15-16 said they are not illegal migrants, we won't be deporting them. Citizenship Amendment Act 2019 says people of these six communities from these three countries, they can apply for citizenship also. That's the main thing. They can apply for citizenship. Alright? So now, obviously, what does it say? So in 2019, they say everyone who is staying in India till 2014. So in 2019, they can apply for it. 2014 is the cutoff date since they should have entered into India. So it actually makes the process of naturalization, it actually reduces the process of naturalization from 11 to 5 years. Fair enough? Now, at the same time, the Citizenship Amendment Act, so first of all, it brings a change the status of illegal migrants from these 6 communities, 3 countries. At the same time, it brings a change to the status of the overseas citizen of India card holders. Overseas citizen of India card holders, they may lose their citizenship if they make minor or major offenses in India. So there can they, if they violate any major, it has been mentioned which laws they can, which it has been mentioned in the amendment that for violation of which acts their OCI card can be cancelled. We need not get into detail, but just thing is this Citizenship Amendment Act also talks about that how it can be affecting the card holders of OCI. Then next. Thing is, Assam Accord says everyone who enters India from Bangladesh, people of Indian origin, entering into India after 1971 would be illegal migrant. Understand this, I am repeating it again. What I am saying is Assam Accord says people of Indian origin coming from Bangladesh before 1971, Indian citizens. After 1971, not Indian citizens, illegal migrants, deport. Citizenship Amendment Act says people who entered before India, before 2014 from Bangladesh can apply for citizenship. It means people who are coming between 71 to 2014 would cease to be illegal migrants and they can apply for citizenship. Don't you think this is going against Assam Accord? Yes, it goes. So what the government says that certain areas are exempted from CAA. What are those areas? Those areas are the areas included in the 6th schedule. And what are the areas under the 6th schedule? The areas under 6th schedule are Karbi Anglong, Dilla-Hasso, Bodoland Territory of Assam, Garo Hills of Meghalaya, Chakma Hills, Mizoram, and tribals areas in Tripura. At the same time, the areas of inner line permit, Arunachal Pradesh, Nagaland, Mizoram, and Manipur. The Citizenship Amendment Act 2019 will not be applicable to these areas. So here I have shown on map on which areas, CAA would not be implemented. 6 schedule areas and the inner line permit areas. Fair enough? Now, what were the old provisions? As I discussed earlier, old provisions were illegal migrants would be deported. They would be deported under Foreigners Act and Passport Act. Now they can apply for citizenship. All right. Now let's talk about the current status, which is Citizenship Amendment Act Rules 2024. The act was brought in 2019 and now it will be implemented through rules which have been made in 2024. The act, Citizenship Amendment Act, it was strict in the sense that the illegal migrants from these 6 communities, these 3 countries, they had to show a passport of their country to show that they belong to those countries. But a lot of these people did not have that document. So now thing is, Citizenship Amendment Act rules, it has brought certain classification. Under Citizenship Amendment Act rules, these people from 6 communities, they need to show 2 things. First, they need to show the place of origin. That they're people, they're resident, they're citizens of those 3 countries. For that, what they can do? They can show any document issued by the central government, state government, even local government of that particular country. That document, it can be birth certificate. That document can be a license. That document can be any other document given by the government. Second thing is they need to prove their religion, that they are from these 6 communities. They also need to give a proof of the date. So what I am saying is they need to show 2-3 things. First, the country from where they belong. They need to show the religion to which they belong. Give a document. They also need to give a proof of their entry date. For entry date, they can give a document which is a license. They can give a document which is Aadhaar. So, or any of these documents they can show to show that they entered before a specific date. Which are those documents? I mentioned over here. There are a list of 20 documents which will be admissible as proof of entry. All right. And I've given a list of these documents in the next page, right? Now, in Citizenship Amendment Act, there was one more condition. It said that a person who is of these 6 communities from these 3 countries should also be knowing a language mentioned in the 8th schedule of India. Under Citizenship Amendment Act rule, there has been little flexibility in that. What's the flexibility? The requirement of a certificate from an educational institution certifying that applicant knows one of the languages mentioned in the 8th schedule has also been done away with. Now just the person need to give a declaration. He need not get a certificate from educational institution. He needs to give a declaration that he is able to speak the language mentioned in the 8th schedule. That will be it. So basically, the rules are giving a lot more flexibility as compared to the initial act. Here I was telling the list of 20 documents. You can go through them. Not required for UPSC perspective. You can do it for your common knowledge, for your general knowledge. Now, there has been a change in procedure through which citizenship is given. We had multiple ways, right? Through birth, through descent, through naturalization, through registration. So if it was by registration, by naturalization, in that case, the person had to apply to a local DM office or a local DC office. And then a person would be getting the citizenship. Now what do we have is, in the current case, so because of this, basically in providing citizenship, the states also had some say, not a direct say, but as DM or the DC would be reporting to the states still had some say in providing citizenship, but the center has done away with it. Under the new rules, there would be an empowered committee and a district level committee. There would be a committee set up that would be deciding upon the application of the citizenship. Who would be the point of contact in that committee? We would have a person from a postal department, we would have a person from the census office, and we would also have a person from Information Bureau, IB. And basically all these 3 entities, they come under the central government. So central government basically through this change has brought all the power of conferring citizenship under this act under its belt. And no power has been given to the state governments even through the DM office. That's why multiple states like Tamil Nadu, Kerala, they're contesting this. They're saying that the new provision of Citizenship Amendment Act, it is going against the spirit of federalism. But again, if I talk about Article 11 of the Constitution, Article 11 it says that it's the Parliament which has the sole right to legislate on the citizenship, and that's what the Parliament has done. So it doesn't go against the concept of the Constitution. All right. Now, this is the detail. You may just go through it for your knowledge. Won't be required in UPSC prelims or mains exam. Now, here comes into discussion which is important for the mains exam. All right. What are the issues regarding it? Citizenship Amendment Act, since it was brought in the year 2019, it has kept the country on the boil. There are a lot of protests in Delhi, in many parts of the country. A specific area in Delhi called Shaheen Bagh, it faced a strong protest for 3-4 months continuously. So now let's talk about the issues surrounding Citizenship Amendment Act 2019. First, it says it goes against the right to equality. Why it goes right to equality? Because right to equality, it prohibits a class legislation. It says that we have equality before law, we have right to law, and we have equal protection of law. The state cannot discriminate against anyone on the basis of religion. And here what we are doing is, the state is giving citizenship based on religion only. So hence people are protesting against it, that this is going against our right of equality. This is the first thing, that why it is only the religion which has been made as a basis of giving citizenship. It should not be religion, it should be open to all religions. Why are Muslims or even Jews or even atheists, why are they not being given citizenship? Why only these 6 communities are giving citizenship? That's one issue. That's what the opposites, or that's the argument against, Citizenship Amendment Act, that it is going against right to equality. Now, what is the second issue? The second issue is, it says it goes against secularism. Constitution, it says we have secularism. Secularism means all religions are equal. So if we are not giving citizenship to a member of a specific community, in that case it goes against secularism. That's what the opposite, that's what the people who are in argument to this act, they say about it. All right. See, they say, why a specific community? For example, if you talk about Bhutan, in Bhutan also, so basically they are saying the stand of the government is that it is giving the citizenship to those people who are facing religious persecution. In specific countries, in these countries, they are Islamic states, and in these Islamic states, these 6 communities, they are facing religious persecution. Hence, again, on humanitarian grounds, we are giving them this protection. But the people who are opposite to it, they say a lot of other people are facing religious persecution. For example, Shias and say Ahmadiyas in Pakistan, they are facing religious persecution. For example, even Rohingya Muslims, they are facing persecution in Myanmar. Even Tamils who are Hindus, Tamil who are Buddhists, they are also illegal migrants in India. They are also facing religious persecution in Sri Lanka. Even Bhutan, it is also a theocratic state where the other religions do not have a lot of freedom as Buddhist people have. So why not to give protection to those people also? That's the stand. That's the argument against the Citizenship Amendment Act. Then we discussed earlier, it breaches Assam Accord, because Assam Accord says since 1971, whoever has entered into India from Bangladesh, person of Indian origin, he is an illegal migrant, should be deported. This act says 2014 till 2014, whoever is entering India, person of Indian origin from Bangladesh, would be given citizenship. Citizenship Amendment Act says not applicable to 6th schedule, tribal areas 6th schedule. But point is, Assam, not all districts of Assam are covered under 6th schedule. We have lot of other areas of Assam, lot of other districts of Assam which do not come under 6th schedule. What about those districts? What about Hindus coming from Bangladesh and settling into those areas, those districts? The people in Assam are apprehensive. This would lead to a loss of their culture. This would lead to a pressure on the jobs. This would lead to a pressure on the land. There would be lot many people who will be queuing up for employment in those areas. So what about the natives of Assam? Won't they face a issue? Won't they face a problem because of migrants coming from Bangladesh into Assam and getting citizenship too? So they have this issue. Then there's the issue of dual citizenship. These people, they haven't given up their citizenship of their countries, and they may be applying for Indian citizenship also. So what about the citizenship of their earlier country? Would they be renouncing it? What happens to that? Again, that's an issue. Then there is again an issue about country of origin. Why only these three specific countries? Why not Bhutan? Why not Sri Lanka? Why not Nepal? Why not Myanmar? We have people facing religious persecutions over there. We should allow from those countries also. Then the other issue is about the fate of rejected applicants. People would be applying for it. Citizenship Amendment Act, it actually gives a pathway how the people from these 6 communities, 3 countries can get a citizenship. But suppose a specific person is unable to give the documents of country of origin or religion or point of entry, and that person is unable to get citizenship. What would be the fate of that person? Would that person be deported? Would that person be jailed? Or would that person be given more time to show the proof? How do we go about it? So Citizenship Amendment Act is silent on that. Then states also say it goes against federalism. Why federalism? As discussed earlier through the power of district commissioner, DC, DM, the states still had power to grant citizenship, but now that has been taken away from them. Some power related to giving citizenship has been taken away from the state, and now in the new procedure of Citizenship Amendment Act, we do not have any power to the DM or DC or the state. So many states are complaining that it is going against the spirit of federalism. And the last, it says it is undermining the pluralism of India. India has been a pluralistic country. We give protection to all religions, and it has been continuing for centuries and centuries, where all religions are treated equally by the state. But here we have a specific religion, people of specific religion who are not given the privilege which people of other religions are given. So the protesters are saying it's going against the pluralism or spirit of pluralism of Indian society. Then what's the legal challenge? So when this Citizenship Amendment Act it came in 2019, there were a lot of PILs filed in Supreme Court, and the amendment was challenged by, one of them was Indian Union Muslim League. Alright, so the case went to Supreme Court, and still there has been no discussion, no decision on it, and the matter is still sub judice. So what Supreme Court says, only time would tell whether Citizenship Amendment Act it goes against right to equality, right to freedom. Let's say it goes against secularism, goes against right to equality, goes against basic doctrine of Indian Constitution. Only time would tell when the Supreme Court judgment comes into picture. All right. Then what are the supporters of Citizenship Amendment Act saying? They are saying that it is actually a win for persecuted religious minorities, and they also claim that the act is passing the reasonable test under Article 14. Because Article 14 says that if the state is differentiating between two types of people, if the state is differentiating between lion and lamb, if the state is differentiating between like and alike, there has to be a reasonable restriction. There cannot be an arbitrary restriction. There cannot be an arbitrary reason for it. There has to be a good reason for the government to differentiate. And the supporters, they say that these people of these 6 communities were facing religious persecution, and therefore it is not going against right to equality. All right, and it is also fair. It is also passing the reasonable test. So now again there have been multiple protests in the country. Now what we what's the way forward for us? The way forward is there has to be a consultation and dialogue. The government should ensure that representatives of the religions, the stakeholders, the NGOs, the civil society, all they get into consultation and dialogue and should be able to convey to the people why we had this Citizenship Amendment Act, what's the reason for it, and it's not brought to exclude a specific community, because there has been this allegation also that Citizenship Amendment Act it is exclusionary in nature, when the government of India it has been focusing on inclusive growth. that growth which includes all sections of society irrespective of caste, class, religion and gender. So when the government says inclusive growth, everyone will be included in the growth process irrespective of religion. How can we not give citizenship to people of a specific religion? It is exclusionary. So that's what they say. So basically now what should be the way forward is, we need the stakeholders, they need to meet, the government needs to ensure the stakeholders meet and have a dialogue to show that the religion, that the act is not exclusionary in nature and it is actually safeguarding the pluralism in India. Actually, by safeguarding these people of 6 communities, look, India has around 80% Hindu population. Remaining are minorities in India. And still through this Citizenship Amendment Act, India has been able to give protection to Sikhs, Jains, Buddhists, Parsis and Christians. So basically if we are giving protection to these 5 more communities, we are actually increasing the ethos of secularism in India and we are not hurting it. And the same thing was, whatever is happening now, the same debate was there in Constituent Assembly when the citizenship part was being discussed. There were discussions that, Sikhs and Hindus, they cannot call any other country as their own country because of their religion. So India should be giving citizenship to any Hindu, any Sikh who is asking for citizenship of India. We should not deny it. The debate happened 70 years back in Constituent Assembly and the debate is still there that, we are giving citizenship to specific people who can call India as their home. Buddhism, Jainism, Sikhs, Hindus, they can call India as their own home. So we are actually safeguarding the pluralism in India, and that's the message the government should give. The last and way forward is the government should give a legal clarity about the implementation of Citizenship Amendment Act regarding in Northeast, in Assam and in Inner Line Permit, so that all the apprehensions which the people of those states, all apprehensions are covered. I hope you have understood what Citizenship Act is, or basically who are citizens of India. How did Citizenship Amendment Act, how does Citizenship Act confer citizenship? Then what is Citizenship Amendment Act? What are its rules? And then we discuss what are the issues surrounding Citizenship Amendment Act and what can be the way forward for us. I hope you have liked the session. Thank you.